today's session focuses more on the different practice questions we have around CT-DPO. And this would be an interactive session in case you have been not part of the previous sessions. It would focus more on the questions that come on your screen. And if you can also respond maybe on the chat section or probably after unmuting yourself, whatever is preferred, right? You could simply unmute and share your response, and then we'll see if it's the right answer or not. And we'll also come up with a rationale on which one is the correct answer and why you also have to think in that perspective where that option becomes the correct one. Without further delay, I would just move on to my slides here. A little bit about Tsaaro Academy. I won't go around this today because we are official IAPP training partners, but we do a lot of data privacy trainings and awareness sessions around in the industry. If it interests you, you might want to go and look into the different resources that we provide as an organization. A little bit about me also. My name is Krishna and I am a director here at Tsaaro. I look after a lot of security, privacy, compliances, as well as implementations. As a matter of fact, just before this call, I was a part of a client call where I was helping them create their firewall rules in terms of one of the responses that they were facing. Someone was attempting to put in a lot of different requests to their website, and I was helping them build those firewall tools. So I believe in a lot of hands-on implementation configuration, and that's also what probably makes me more curious about our domain, information security, data protection, or data privacy in general. Now let's look at the questions, and the questions are based on mostly on the GDPR, but there are also questions coming in from different regulations wherever we see a delta. For example, some regulations may focus a lot more on data localization than EU. And when they say data localization, it doesn't mean that you can do a TI and get away with it. There may be stricter repercussions on what happens when you actually transfer data from their jurisdiction area or geographical jurisdiction to a different country. Some regulations also may have different DPO registration requirements or registration with their national authorities as well. And we will also incorporate questions around those regulations within the final quiz that you would see for your CT-DPO practitioner course. Now, let's also look at the questions here, right? The first question is, which of the following statements is true regarding a cookie consent framework for organizations processing EU citizens' data? Right? So if you could put up in the chat section, all of you, what do you think is the right answer here? And I think bonus points for if anyone can tell me which is the actual law or directive that governs cookie consent or anything around cookies. Is it the GDPR or is it something else? Okay. I think a couple of people say that C should be the option. Okay. Prakash also agrees with C. Anyone else? Okay. Guys, feel free to unmute yourself and feel free to also let us know why do you think C is the answer. Do you think cookie consent frameworks only focus on personally identifiable information, or is it only required when any kind of personally identifiable information is collected, or is it just in general, right? Because GDPR is not the governing law when it comes to cookies. What we look at is the e-privacy directive, and the e-privacy directive, or the famous the judgment, right? The Court of Justice judgment around this organization known as Planet, something I don't remember the second word, but there's a very famous judgment around the Chief Justice of European Union, 49, right? If you can just type in that keyword, you will also understand a lot more about cookie consent frameworks. So the answer here is not actually C, the answer is B. Right? If you have a cookie consent framework and if you have a cookie notice in different geographical jurisdictions, then you also have to give out an option to read that cookie consent in their local language or probably the language that is used for official communication. For example, if you have a website that is accessible in the Germany region as well, you need to make sure your cookie consent as well as your website is available in German. The third one, cookie consent frameworks are only required for websites that collect PII, is wrong. It's a very common misconception. But at the same time, if you look at the e-privacy directive, any kind of placement of cookies or any gathering of technical details from a person's endpoint maybe a mobile or laptop, falls under the purview of this particular section or e-privacy directive. Right. So the answer here is a very common misconception. C is not the answer. The answer is local language is required in the cookie banner. Yeah, Anis, Ajay, if you have any.
Yeah, it means we have to dwell into more for this GDPR and this guidelines, etc. Yeah.
That's right. So GDPR focuses more on PII, but there are
Yeah.
also supporting guidelines such as the e-privacy directive, which
E-privacy
focuses.
directives, yes, yeah.
Right.
Thank you.
Sure. No worries. Don't worry about getting the wrong answer because we have made it intentionally a bit difficult. We don't want to throw easy answers at all of you, easy questions.
Yeah, of course. We have to have a clarity only through this discussion and have this to remove misconceptions at our end.
Exactly, exactly. Perfect. So I think the first question also sets that kind of tone for the kind of questions you would see ahead. Right now, I'll
Right.
go to the next one. Let's look at the
Yeah.
second question. So
Yeah.
a company collects user data through their website and mobile app. They want to ensure that they are in compliance with privacy laws while still being able to use the data for analysis. Right? Which of the following is an appropriate step for the company to take in order to achieve this goal?
Company collects.
Right. Right. Waiting on. Okay. Ajay says it's A and C. Shashank and UKP feel it's B. Okay. Right. Okay. I think most of you got it correct. The answer is B because I understand that the company wants to ensure that they can use data for analysis, but they also want to comply with the data privacy law. So in terms of complying with it, you have to make sure that you have a comprehensive data retention policy, which talks about the different requirements for when can you store a certain kind of data and why are you storing it, right? The reason behind it and the purpose of processing that data and whether user consent was obtained for it, right? So that's okay. No problem, Ajay. Right. So the answer for this one is B. You need to develop a comprehensive data retention policy to ensure data is not kept longer than necessary. And it may sound like creating a data retention policy is easy, but in fact, it's one of the most difficult tasks that you would come up with while you are developing all the policies for data privacy compliance. Because data retention policy, you'll have to talk to a different set of service lines or business functions, understand what are the other overlapping laws that can potentially make you store personal data. You also have to comply and understand, can you actually delete that data when you say that you would delete it in 2 months or 3 months, right? Are your systems capable of deleting that data? Or is there some kind of analysis or check that you do after deletion of data, whether the data is being disposed of in the right or appropriate manner or not? Right? Because I heard of a recent data breach where this organization was disposing its media through a third party. They were also obtaining certificates that the third party disposed of their media, their hardware media, in a safe and secure manner. But turns out this third party actually sold their assets instead of disposing it, and some malicious actor got a hold of one of their assets, and it led to a widespread data breach for this organization only because of the kind of data that was present on that particular device. There was no magnetic degaussing done. There was no deletion of data done. It was just disposed to a third party, saying that the vendor is accountable for it, right? And in the end, the vendor was held accountable. So creation of a data retention policy is very, very important, and you will have to discuss it with a lot of different business functions to identify the right date, the right duration of keeping of that data, as well as your technical feasibility of making sure that you can actually comply to that. Right. Looking at our next question, a hospital wants to use patient data for research purposes. They are concerned about maintaining patient privacy while still being able to analyze the data. Which of the following is a privacy preserving technique that the hospital could use? Right. So which of these is a privacy preserving technique that comes to your mind?
I think they can do the pseudonymized patient data before analysis, because later on they will again need this data so that they can refer back to the specific patients.
Mhm. So Anis, in case this is again a trick question, because there's also option D, right? Because option D talks about anonymizing personal data or patient data. Now,
Okay.
anonymization is more of a privacy preserving technique than pseudonymization, because GDPR still applies even when you pseudonymize data, but GDPR or privacy laws won't apply if you anonymize personal data. Right. And in the same case, if you're doing it for research purposes, or if you're trying to analyze data for research, then you don't necessarily need to know the patient's name or a unique identifier where,
Yeah, yes, I agree.
Hi,
I missed research purpose. Yes, sorry. Yeah, I
hi,
agree.
Krishna. Can you just tell me like what is pseudonymized means?
the difference between pseudonymization and anonymization.
No, I know what is anonymized, but can you tell me the option A?
Sure. So pseudonymization basically, pseudo means fake, right? So pseudonymization basically means that you are making sure that the data is masked, but at the same time, there is a key that you can use to unmask that data in the future, right? When we talk about anonymization, there is no way to actually go back to that personal data anymore. But with pseudonymization, there is a key that you can use, or maybe a password or a private key in terms of a public private key cryptography algorithm. You can use a key to get back to that personal data again. So if there is any way of going back to the original personal data, it is pseudonymization. But if there is no way to go back to that personal data, then it becomes anonymization.
So in this, there is a particular time limit or what? Any time frame, or there is nothing, no time?
There's no time frame as such. There's simply a key which can get you back to that personal data. That's all.
Okay.
At least for me, the lesson here is that we need to read the questions very carefully.
That's true. We also try to make sure that the CT-DPO courses are difficult,
Yes.
right? Because
Yeah. Right.
what we have actually seen is that more people pass CIPP and CIPM than CT-DPO, right?
Oh,
So
really?
yes, it's also another metric that we use to discuss this. So
Yeah. Okay. Good. Thank you.
perfect. Looking at question 4, Alpha companies collecting data from its customers to provide them personalized services. However, the company is retaining data for a longer period than necessary. What does this violate? Which of the data processing principles that we commonly use does this violate? Right, waiting for your responses on the chat section, everyone. Okay. Right, I think Hannah, you have the right answer here. Data minimization is the right answer, because when you focus on data retention, or when you look at data retention, it directly correlates to one data processing principle, which is data minimization, right? So you only have to collect and retain data for a period that it is necessary. Any kind of delay or any kind of extra storage of data means that you are storing data when it's not required. So it violates the data minimization principle. Now, what you have to do here is you have to understand the data processing principles, because if the company is retaining it, it is making sure the data is available, right? So that means that option A is not right. If the company is retaining it, it also means that it is probably using the right kind of technical and organizational measures to protect that data. So data protection goes out of the picture. Data integrity, if the company is storing that customer data and also providing them personalized services, then it means that they need to have accurate data set, right? If they don't have an accurate data set, or if they don't have accurate personal data, they may not be able to provide actually personalized services, right? So the only option that remains is data minimization. They have to minimize the data that they're collecting, especially when they are retaining data for a period that's longer than necessary, right? So data minimization would be the correct answer here.
I thought that this data minimization is only at the stage of collection.
No, it goes in the entire stage of data lifecycle.
Entire stage of the life cycle. Very good.
That's
Thank
right.
you. Yeah.
But Krishna, means if we talk about like data minimization, so as Anish mentioned that it is should be like how much data we are collecting. So I think the question, from my understanding, it's like misleading. So I think it should be either the best choice available should be the option here, because again, minimization to our understanding, what we have understood that when we are collecting the data, so the data that is only required for your purposes, whether that's marketing or from like hospital point of view, or maybe for any required industry. So whatever is the required information that should be only collected, to use the term data minimization.
That's right. So Shashank, as I mentioned, data minimization focuses on the entire data lifecycle management, not only in the case of collection. It also focuses on when it's stored, and if it's being stored for a period that is not accepted by your data retention policy or not defined by it, then it directly violates the data minimization concept as well. So if you look at the entire data lifecycle management, all the data processing principles apply on all of it, all the lifecycle management stages that we have in terms of collection, processing, storage, deletion, right? The data processing principles actually map to all of these requirements.
Okay.
Right. Looking at the next question, in which of the following scenarios is it permissible to use cookies without user consent? This is a fairly simple question, guys. So in which of the following scenarios is it permissible to use cookies without user consent, right? Even if the person does not consent to it, you can place these cookies in terms of strictly necessary, or anything that comes to your mind. I've also given kind of a hint there. Okay, I would like all of you to go through all the options, please, before coming up with the response. So go through all the different options once.
Maybe D, Krishna. The website uses cookies to protect from malicious attacks, and cookies are required strictly only for functioning of the website.
Yeah,
That's right.
It should be D, correct. We went too fast.
That's right. D is the correct answer, right? First party cookies, if you are an organization that's probably a tech organization, it's very likely that you have developed your website from scratch. And if you've done it, you are also potentially using a lot of first party cookies for your analytics, or maybe for the user profiling. So first party only means cookies that belong to you as an organization. You are the one who created those cookies. Right. So it does not mean that first party cookies and strictly necessary cookies are the same category. No, first party cookies are only when your organization has developed those cookies, or you're not using a vendor's cookies such as Google's ID, Google ID, the GID cookie that you usually see, or Google Analytics cookies, or maybe LinkedIn cookies or YouTube cookies, right? So you're not using those ones. So, and second party focuses more on the platforms that you used to build your website. Those cookies that come with the platforms are most likely your second party cookies. Any kind of third party integrations that you do with LinkedIn, YouTube, or all these different social media platforms fall under the bucket of third party cookies, right? So the answer here would be option number D. Only if you're using cookies that does not profile the user, or only if you're using those cookies to make sure that the content is rendered in the correct way and the content is provided to the user to support the functioning or the natural functioning of the website. Only in those cases you may not need consent and you can move ahead with it. Even then, you have to create a cookie banner and ask for the consent, right? The user can decline it, but still you will use your strictly necessary cookies for smooth functioning of your website. Okay. Looking at the next question, a healthcare organization wants to implement a PIMS, or a patient information management system, to securely store patient data. Now, which of the following is the best way to ensure privacy of patient data? Right, take your time and respond to this.
I think option A, Krishna.
Yep, that's right. Right. Option A is the correct answer here, right? Using strong encryption for all patient data stored in the PIMS. And at the same time, if you are a privacy professional, you will have to focus a lot on IT systems as well, and the underlying principles on how IT systems work, right? You don't need to be a developer. You don't need to be an engineer of any sorts, but you need to understand the different protocols where personal data may be involved, especially if you're doing a data protection impact assessment for a platform such as a PIMS. You would want to understand the different protocols in use, what are the vulnerable versions of those protocols, and if those organizations are using those vulnerable versions or not. Just a basic simple Google search would help you get that information. So you'll have to look and focus a lot on that as well. Just the basic understanding and the data flow of IT systems and within IT systems. So the answer here is A, use strong encryption for all patient data stored in the PIMS. Okay, now the next question, a bank is considering implementing a PIMS to store customer data. In this case, the PIMS is the Privacy Information Management System, right? So the bank is considering implementing it to store customer data, which includes sensitive information such as account numbers, transactions, personal information, and the bank wants to protect customer data in the PIMS to prevent data breaches and implement appropriate security measures. Right, I think
I think it's D. If I am correct, it should be D. Implement role-based access control.
That's right. That's right. I think I made an error here. I didn't put up the question. The question is basically which of these would be the best way to protect security measures. Yeah. But yeah, I think
so that was understood.
Yeah, that's what
Krishna,
I figured.
I will just take a few minutes, a second, was to share something.
Sure.
When I started working in Bank of Baroda way back in 1984-85, during training we were told this need to know basis.
Right.
Yeah. So this is the thing. This implement control based on implement role based access control.
That's
so that
right.
is related to that. Yeah.
That's right, and he's absolutely spot on.
Need to know. If there is a need for me to know something, then I should know it or share it. Otherwise, no.
That's right. So when you look at access controls, these two things, right, need to know basis and least privilege principle is something.
Yes.
Yeah. So these are two things that are used widely in the access control discussions. So you are absolutely right there. Need to know basis and least privilege, but role-based access control is one of the more modern topics, or the replacement of both of these, which is where we included that here instead. But
you see, now we are speaking a new language.
That's true. That's true. So the keywords keep changing, right? As technology advancements are there, we have seen the keywords keep changing.
Keep changing. Yeah. Thank you.
Sure. Okay, I think Love also has a question. One question from cookies section. I was under an impression that such cookies are used primarily for preferences to keep a record users, like such as in music or shopping. What if I do not want to share my preferences to any application? So Love, ideally, if a categorization is not made where you get to choose what kind of preferences you want to share with the customer or with the organization, then they are not implementing the right kind of cookie consent framework. Because under the GDPR and as per the latest judgment, the CJEU Planet 49 case, and remember it now, the Planet 49 case, if you look at it, basically what it says is that there needs to be a website wherein the website or organization stores no personal information at all, right? And they only make sure that the website is available to a user. But in case there are certain cookies they want to place to understand or personalize things, then what it means is that they are profiling you, right? They are creating an individual user profile for you. And if they're doing it, they are collecting a lot of personal data. And it also automatically falls under a high risk category. Any kind of profiling falls under a high risk category. And if they are not giving you the options to select the cookies that you want, it means that they are not doing it right, right? So a lot of Indian organizations currently do not do it right because India does not have a governing specific law yet. But if you look at European Union specific organizations, most of them provide you the different options to choose the kind of cookies that you want to be applicable to yourself. right? So if you do not want to share your preferences, ideally they should give you that option. If they don't, they are against the law. But law of the land works, right? But so in India, it won't matter. But if you also read the SPDI or the sensitive personal data information rules for body corporates, you would see that even they have to follow certain aspects of cookies as well as collection of sensitive personal information. So it's a tricky thing on how to do it, because organizations technically don't. And there is a European watchdog known as NOYB, none of your business. And I mean, that's the name of the organization. It's not that I'm responding that to your question. So it's the name of the organization, NOYB. It's a organization that is run by Max Schrems, right? One of the famous people in the privacy world. And they look at different organizations' websites, privacy policy, cookie policy, and send out notices to them saying that your privacy policy or cookie preferences center is not compatible. Then this organization has some kind of time to respond to them. If they don't respond to them in time, NOYB puts out a complaint to the supervisory authority, right? So these things are happening in the European Union, and we'll wait for how it turns out in India. Right, so sorry, just focusing that the answer here would be option number D, implementing role-based access control. Now let's look at question 8. ABC Corporation is a manufacturing company experiencing declining profits due to inefficiencies in its operations. It decides to implement a process improvement management system. So, right, this is why I focused on, or I asked a lot of you to focus on different IT systems. So there were 3 kinds of PIMs that we saw, right? One was the patient information management system. One was privacy information management system. This third is process improvement management systems. Right, so IT has a habit of using fewer words to explain a certain concept, and PIMS is one of them. There are 3 different kind of PIMS that you would probably see, or maybe more, in terms of how an organization is using that acronym. So this is why I asked you to specifically look into the different IT services whenever you're considering your privacy program. Right, now coming back to the question, the company decides to implement a process improvement management system to streamline its processes and increase efficiency. And there's a project manager who would lead the implementation process. What role does senior management play in the PIMS implementation process in ABC Corporation? Right, so this topic is basically directly related to the governance part of privacy. How do you think the senior manager should be involved?
It should be option C, Krishna.
Okay.
Yes, I also go for C.
Yeah, I think we also have that answer in the chat section as well. Option number C is the right one, right? If you are implementing a process, or if you're implementing a system that affects the entire organization, then the senior management needs to take constant updates, maybe weekly updates, or based on the sprint life cycle that this organization or this project manager is defining, the senior management needs to be involved and needs to take those relevant updates as well, right? So the reason for this question also is because there may be certain systems that are in silo, or that is probably being used by only an individual team. In those cases, it may not be required for the senior management to actively be part of the implementation process or the implementation program. Right, so that's also the reason for this question. And what I also want to share with you is that you have to understand the level at which an IT system is being implemented. Right, so if you understand that, then of course you understand how to implement this as well. Question number 9, which of the following statements accurately describes the problem that a DPO may face when tasked with drafting a data retention schedule for a healthcare organization? Okay. The purpose for which the patient data was collected must be considered to ensure compliance with data protection laws. Okay. Right. The answer for 8 was option number C. Senior management's involvement is critical through the implementation process. Right.
Yep, I will also go with option C, Krishna.
Okay. Right. Anyone else, if you have a difference in opinion or want to understand why option C is the right answer?
I will also go for C, Krishna.
Yep. C is the correct answer.
Yeah. The purpose for which the patient data was collected must be considered to ensure compliance. Yes.
That's right. So here the data processing principle of purpose limitation comes into picture. And it actually is a very complicated problem when we're trying to understand the data retention schedule, because there may be certain departments that are collecting this data and which is not very easy to map when you're trying to delete that data when it goes beyond the data retention schedule, right? So option number C, the purpose for which the patient data was collected must be considered to ensure compliance with data protection laws is the correct answer here. Right. Looking at question number 10, which of the following factors should website owners consider when determining the appropriate cookie consent framework to implement? Right. I think based on the discussion we had around the previous cookie consent framework related question, I think all of you should be able to get this answer right. Okay, Prakash has option number D. Ajay also responds with the same. Yeah, I think all of you are right there.
It goes with the yes.
Perfect. All of the above is the right answer here. We also have a cookie compliance checklist on our website. So if you want to look at the different kind of settings one assesses when they look into cookie compliance, you may want to look into that as well. It will give you an idea of the different areas of concern when you're doing that cookie compliance audit and the different sections or checklists that you need to maintain while you're checking for it, right? So the type and purpose is important. Geographic location, because we want to make sure that we can provide the cookie notice in that particular language in case of a language barrier. Yeah. Websites, legal obligations under privacy regulations. There may be overlapping data privacy regulations. There may be other regulations that support this as well. So you may also want to look into that based on geographical jurisdiction. So which means the option number D, all of the above, is the correct answer here. So great job, everyone. Great job on this one. You got this one correct, all of you. Now, this one again is a trick question. A social media company has experienced a data breach that has exposed user passwords. Which of the following steps should be taken first? The first step, right? Remember, the first step. I mean, all of them should be done, but which one should be done first?
I think A, notify affected users.
Okay. Does anyone feel C could be the right answer as well?
Reset all user passwords.
So C could be an option, Krishna, but ideally that communication should go to the affected users to change their password as part of this breach. That's so right. I think the appropriate option should be A, notifying affected users.
That is right. In this specific case, notifying affected users helps better because if you have a data breach that has exposed user passwords, and if you're sending an email to that very specific email to reset their password, it is counterproductive, right? So it won't really help you out in any way because you're sending out an email to an email that's already been exposed. So, I mean, it won't be possible for the user to reset all passwords. So you have to notify the user, maybe through an email communication, maybe through a public notice, or maybe through any other communication channel. And then when you do that, you have to tell them to change their passwords themselves, because it's very likely that it would, the email communication that goes out to these emails may not come from the organization. And how does a user who is not a very, security centric or a privacy centric professional, how would they know that it's not a phishing email, right? So the right step would be to notify them first so that the users can take reasonable steps to reduce the harms caused by this data breach, right? So I'm mapping it to the data privacy discussions we have around harms caused to a data subject. So the reason why we have to notify users is because we have to notify them that there has been a data breach, your data was involved, we want you to take an action so that you can reduce the impact of this data breach, right? And first option number A, is the right one here.
Yeah, Krishna, I have one question.
Sure.
So we need to notify users, right? Whenever like there is a breach on encrypted data. So do we need to notify the district council or attorney general in that sense?
It actually depends. If there is a malicious actor involved, then you may have to notify, the relevant regulatory authorities, or maybe the police as well, in case you feel that the data breach was not insider driven, or maybe it was just an accidental data breach. If it's an accidental data breach, you may not need to involve the police or any other body. But if it's a planned malicious attack, maybe an insider threat, insider who leaked that data breach, or maybe a third party that was trying to deal in corporate espionage, right? If those kind of activities are there, you may have to involve the bodies, the different police bodies, or maybe supervisory bodies in this case, or regulatory bodies as well.
Okay, so in case of like only the encrypted part of the data has been leaked, and the main, like where you have stored the data, like the vault access or something, that is not breached, we still have to notify the users and the this.
Yeah, so in that case, it may not be necessary if you have if there is a encrypted breach of data. I mean, there was a data set which was fully encrypted, right? And the hacker or maybe the malicious actor does not have the key to that encrypted data, then it may not be necessary to notify the affected users. But based on your country's local law, you may have to notify the supervisory authority. For example, the Indian body says that you will have to notify them in case something like this happens, because it still constitutes as an incident.
Okay, cool. Thank you.
Sure. Okay. Love has a question. Why not identify the source and extent of breach at first? So, Love, it's very complicated to identify the source and the extent. And there was an IBM report that said that it takes an organization at least 270 days to even realize there was a data breach or there was an incident, right? So I think what we probably don't realize is the scale at which organization operates, right? If it's a global organization that's operating in different jurisdictions, imagine the number of logs that they generate. It could be in, PBs, right? Petabytes. So it's a lot of data, and to collate all that data and to actually realize something is going out, it is not that simple. So if you have read the news recently, there was a very infamous case of fraud for one of these edtech giants, where two people were, they kind of swindled a lot of money, probably somewhere around 12 crores from this organization, by creating fake teachers, by selling fake courses. So it took the organization a good 8-10 months to identify an incident like that, where they are actually losing money. So now imagine how long it would take them to identify a security incident, right? So it's not very easy to identify that, especially because the organization also does not put in the right kind of resources for that identification. Because in the end, every organization is business oriented or business specific, right? Their main goal is to conduct business. Everything else probably comes as an afterthought or maybe a support function. So just from a perspective of CEOs or executives, it's not something that can be done very easily. Even if you have the best tools, right? If you have the best SIEM tools, if you have the best SOC analysts, it would still take time, because the amount of logs that are being generated, the amount of malicious requests that come in to map it, to come up with a RCA or a root cause analysis, definitely always takes time, no matter how much you templatize it. Sure. Let's look at the next question, a bit of focus on privacy by design now. So an e-commerce company is developing a new feature that allows users to save their credit card information for faster checkout, right? If you are in India, you might have seen this a lot these days, right? There is an automatically opt-in box that you would see when you are using your card information, that we are saving your credit card for future checkout. You can opt out if you want, but by default it's opt-in, right? So how can privacy by design principles be applied to this feature? Okay. Right. I think the answer here would be option number D, Because if you look at privacy by design and the different principles, you can map each of these principles to option A, B, and C. Right. If you look at end-to-end lifecycle protection, probably you can map it to option B. If you can put the other one where we have to create clear, concise, transparent notices, you can map it to option C. Give the right back to the user, you can map it to option A. Right. So the answer here would be all of the above. These are all privacy by design requirements or principles that you can map it directly to the 7 principles under PPT. And I was also lucky enough to be one of the attendees for the person who actually introduced this concept, Anne Kovakian. She recently had a webinar pretty late for our time, 12:30 a.m. But I had to attend that webinar. And I think she's a very passionate professional when it comes to privacy, and she was just raising her concerns around how privacy by design is not being followed these days. Okay, I think MB has a question. Try downloading the quick consent checklist, but intersection of GDPR and blockchain is being downloaded. Probably an error from our end, MB. Let me have that check with my operations team. Right, they will share the cookie consent checklist with you directly. And I think there's an issue with the hyperlink that's being put there. My apologies for that. We'll take that into consideration. Right. So option number D, all of the above is the right answer here when it comes to privacy by design principles. Yeah, I think Mukul, I think the issue is that there is a hyperlink issue, probably because of update of a newer one, right? So can you just send out the template instead? Yeah. Okay, now a financial institution is developing a new online banking platform that allows users to view their transaction history and account balances. How can privacy by design principles be applied to this platform? Right, waiting for your responses, everyone, if you have the time to read through this question. Okay.
I think I will go by A.
Okay, but did you get a chance to read through all of the options?
I cannot read the last one. Can you just downsize your screen? Maybe it's out.
Sure, let me see if I can do that.
Yeah, it's okay. It's okay. Yeah. No. Again, it's gone. Last one is gone.
Okay, let me see. Is it better now?
Yeah, it's better now. It says all of them by ensuring that users are informed about how the data will be used during the consultation.
I think it should be option D.
That's right.
Yeah.
Fairly simpler ones, fairly a simpler question than the ones we've shown before, right? All of the above is probably the best choice when you see.
Best choice. I agree. Yes.
Yeah. So even if you're going for your IPP certifications, when you see all of the above and none of the above, look at the question extra carefully, because it's very likely that those options could be the answer, right? Because there's probably some nuances that they have secretly put into the statements that you would want to re-verify when you read through it.
Right. Thank you.
Sure. Now let's look at this one. A financial institution has a data retention policy that requires retaining customer transaction data for 5 years. A customer has requested that their data must be deleted from the institution's records using a data subject request. So what do you think is the best course of action in this case?
Option D.
Okay, I hope you had the chance to go through all options again.
Let me.
I think it should be D, Krishna.
Yep, that's right. So this may actually happen, right? In case there's a DSR that is coming to you and a user says that delete my data, right? But there may be an overlapping regulation which says that you have to retain that customer's transaction data for maybe 5 years or 7 years based on the financial law that comes in from a different regulatory authority. In those cases, you definitely have to retain it because you have to also honor the other law that is applicable. But before you retain it, the first action that you need to do is you need to notify the user that because of the applicability of this particular law, we have to look into storing this data for an extended period of time, at least 5 years. And after the 5 years period, we can delete it, right? So notify first before retaining it.
Right.
Sure. Right. So I'll just rephrase this. The answer to this question is option number D, notify and retain customers' data for the minimum retention period required by law, then delete it. Okay, now a healthcare organization, I'll just take this up as the last question because the other 4 questions, I know that you would be able to answer it based on the discussions we've done so far. And I'll also share this PDF file with you, right? So you can also go up by yourself. I'll not share the answers because it makes things easier. And I want all of you to personally go through it and understand which answer would be correct. Probably have a discussion on the groups that are available to you. Right. So looking at this last question, a healthcare organization is developing a new electronic medical record system. How can privacy by design principles be applied to the system? Right. I think this one also goes to all of the above. So I'll just skip this one. Let's go for this one. Right. I think this is a better question to ask. So the question is, a large retail company suffered a data breach in which customer names, addresses, credit card information were stolen. What is the first step the company should take to manage the breach?
See, ideally, option A is both correct, but I will go with option A.
Option A was stolen. I think because the credit card information is stolen, it's very necessary to notify the affected customers immediately.
Okay.
Before even going to the local law enforcement authorities.
Mm-hmm.
This is what I feel.
Okay. I think, yeah, so basically Love and Shashank, I think you got the right answer. In this case, only in this case, right? Because there was a crime committed, right? The information was stolen. So you will have to notify the law enforcement authorities because there may be additional discussions or additional insights that they would be able to give you so that you can also identify your next step of managing that data breach, right? Because what if it could be a nationwide attack, right? Or maybe an advanced persistent threat out of a different rogue nation that is performing this attack on different critical infrastructure, and because you're a large retail company, you were also part of that attack, right? So you will probably have to notify the law enforcement authorities first, only because you are a large retail company and this information was stolen, right? Not in most cases, you may not have to notify affected customers, right? Only if the GDPR is applicable and there is a law that talks about notifying affected customers, you will have to do it. But in certain cases, if you see that the customer names, addresses, and credit card information was encrypted, then you may not have to notify your affected customers at all. So the first thing you do when a crime has occurred is that you notify your law enforcement authorities. Then again, the other steps are definitely important. You may not need to hire a cybersecurity consulting firm if you have an in-house team. You can do a forensic investigation by yourself. But most organizations do not have an in-house forensic investigation or an incident response team. But if you're a large retail company, it's a high likelihood that you would have a team such as maybe Target, for example. Target is a very large organization and has one of the best cybersecurity practices in the world, right? They have patented their cybersecurity technologies. They are at that level where they can conduct a forensic investigation. So really depends on your organization because you're a large retail company and a crime was committed. So you have to notify law enforcement authorities first. Then based on their insights, you can also determine whether you need to notify affected customers. So I think with this, I'll also pause and close this session for today. And I'll also stop the recording for now. Thank you, everyone.